What if I told you that the most powerful person in a courtroom isn't, the judge sitting up there elevated in the black robe holding the gavel, but actually the barista sitting quietly in the second row of the jury box?
Yeah, it completely upends how most of us visualize the justice system. I mean, we're conditioned to see authority in those official symbols of the state, right? Not in the ordinary citizens who are just kind of quietly observing from the sidelines.
Right, exactly. And yet, if you are like most people, your immediate reaction to actually participating in that power is just this heavy, audible groan. I mean, picture this. You go out to your mailbox, you pull out a stack of envelopes, and there it is.
Oh, yeah, the summons.
Yeah, that unmistakable, highly official-looking piece of mail from the local court, the dreaded jury summons, and you immediately start running through your calendar, right? Thinking of, well, every possible excuse you can muster to get out of it, like work is too busy, or I had a trip planned, anything to avoid sitting in a stuffy room with strangers for days on end.
It is, it's almost universally viewed as this massive inconvenience, just a total disruption to our perfectly scheduled modern lives.
Completely. But this deep dive is going to completely flip your perspective on that envelope. We're exploring some really fascinating concepts today, drawn from a text simply titled The Jury, which is a piece found within this larger book called The Legal Philosophy of the Common Law by Mr. Yong Kang.
And Yong Kang's analysis here makes a profoundly compelling argument. He posits that this system, this idea of relying on 12 ordinary, randomly selected citizens, is not just some quirky, outdated courtroom procedure that we just hold on to out of, pure tradition.
Not at all. So the mission for our deep dive today is to unpack how this specific system is actually the ultimate defense against state oppression and truly the beating heart of the entire common law tradition. So, okay, let's unpack this. Because to truly understand this, we have to look at a detail that is so common to us, we kind of completely forget how wild it actually is.
You're talking about the unanimity, right?
Yes, I'm talking about the requirement of unanimous decision.
The sheer friction that unanimity introduces is just staggering. I mean, in criminal cases determining guilt, or even civil cases determining a tort violation, the decision must be universally agreed upon by these 12 free individuals.
Which is exceedingly rare in the history of world law. Like, getting 12 random people to agree on what toppings to put on a pizza is nearly impossible, let alone agreeing universally to deprive someone of their liberty or their property or even their life.
Yeah.
Yet, this tension-filled feature is somehow the absolute bedrock of our legal tradition.
Right, because by demanding absolute consensus among a dozen ordinary people, the system deliberately makes it incredibly difficult for the government to simply punish someone. The state has to clear an impossibly high bar of persuasion.
It's like a built-in obstacle course for the prosecution.
It really is. This isn't a glitch in the system, It is a feature designed to ensure that the state's power to crush an individual is heavily bottlenecked by the community itself.
Which brings us to the core of why this unanimous requirement actually exists, and it really leads us to understand who actually holds the power in that courtroom. Because when you walk into a courtroom, I mean, your eyes immediately go to the judge.
Oh, sure. They have the robe, the elevated bench, the official seal behind them.
Yeah, they look like the absolute boss.
Yeah.
But reading into this philosophy, I realized we completely misunderstand the power dynamic.
We conflate authority over the room with authority over the truth.
Right. So I was trying to visualize this, and I thought, okay, if a trial is a restaurant, the judge isn't the chef making the meal. The judge is just the health inspector and, the maitre d'.
I like that analogy.
Yeah, they maintain order in the dining room. They explain the menu to everyone, which, are the legal rules, and they handle the final bill at the end, which is the sentencing. But the jury is the chef. They're the ones who actually taste the raw ingredients, weigh the evidence, and they are the ones who create the final verdict.
That's spot on. And to take that analogy even further, if the maitre d' walked into the kitchen and tried to season the soup themselves, that would be grounds to shut the entire restaurant down.
Wow, yeah.
Within the common law tradition, the jury is not some ornamental appendage to the judicial system. They are the ultimate exclusive body responsible for determining facts and assigning responsibility.
Not an ornamental appendage. I love that phrasing. It really underscores that the jury isn't just there for decoration or just to rubber stamp the judge's opinion so everyone can go home.
It is a vital distinction. As to the core questions of the case, like whether the defendant is actually guilty or whether the conduct is unlawful, The judge not only may not decide, but they must not even hint at a personal opinion.
Really? Not even a hint.
Not at all. If the judge subtly nods or frowns while a witness is testifying, heavily implying what they think of the evidence, that can literally trigger a mistrial.
Which is incredible when you think about it. You have this legal expert who has dedicated their entire life to the law, sitting right there on the bench, and they are strictly forbidden from weighing in on the actual meat of the case.
Because in a common law court, those who truly judge the truth are the jurors. The judge is merely a presiding officer over procedure and an interpreter of the statutes. This institutional design reflects a profound vigilance against the concentration of state power.
And for you listening, think about what this means in practice. If you are brought up on charges, state officials and elite legal experts aren't the ones judging your character or your actions. Your peers are. The mechanic down the street, the school teacher, the barista. That is a massive intentional transfer of power away from the government.
It is a radical decentralization of authority. Guilt or innocence, right or wrong, is not decided by the state apparatus. It's decided by the collective judgment of ordinary citizens.
But this immediately raises a huge question for me, and honestly, it's a point where I really struggle to completely agree with the system. If the jury holds all this immense power to decide facts and assign responsibility, wouldn't we want the smartest, most highly trained legal minds sitting in those 12 chairs?
You'd think so, wouldn't you?
Yeah, like wait, if I'm involved in a highly complex lawsuit, say, a massive $50 million corporate patent dispute, wouldn't I want a lawyer or a tech industry professional on the jury? Why are legal professionals deliberately excluded from the jury pool?
Well, what's fascinating here is how the philosophical foundation of the common law addresses this exact paradox. In modern legal systems, this seemingly counterintuitive rule persists, where legal professionals are routinely struck from juries.
Always.
Yeah, and even if a lawyer somehow makes it onto a panel, they're strictly forbidden from instructing the other jurors or offering, professional guidance.
Which still feels entirely backward to me. If my car is broken, I want a mechanic, not 12 random people guessing what a carburetor does. Why would we want amateurs deciding complex civil or criminal fates?
Well, the mechanic analogy makes sense for fixing a machine, but the common law argues that a trial is not a mechanical problem, it's a moral evaluation. The system holds a deep caution against allowing what we might call professional rationality or technical rationality to overwhelm common sense.
Professional rationality, meaning getting so bogged down in the technical letter of the law or the intricate mechanics of a statute that you lose sight of basic right and wrong.
Precisely. The philosophy Yong Kang outlines is grounded in the natural law tradition. The underlying belief here is that justice isn't a math equation to be solved by bureaucrats. The premise is that at the moment of creation, God or nature, depending on your philosophical leaning, implanted a capacity to distinguish good from evil within humanity.
So like a universal conscience.
Yes, conscience. And the crucial element of this philosophy is that this conscience isn't the product of going to an Ivy League law school or reading massive legal textbooks or passing a bar exam. It arises simultaneously with human existence itself. It is universal. It is enduring.
So the system actually believes that true justice doesn't come from a textbook. It comes from that innate moral compass we all supposedly share.
Exactly. And if you contrast this with heavily bureaucratic legal systems where, say, a panel of professional state judges reads a rigid code and mathematically applies it to a defendant, you really see the difference.
Right.
The jury system rests on the conviction that justice is revealed through the judgments of ordinary people's consciences. If you allow a legal expert onto the jury, you risk that expert using their technical jargon to basically bulldoze the collective moral intuition of the group.
Oh, wow. Okay, I see the danger now. The expert says, well, technically under subsection C, paragraph 4 of the corporate code, this is the result. And the rest of the jury, feeling kind of intimidated, just defers to them. They abandon their own gut feeling of what is actually fair.
Exactly. The expert judgment supplants the common sense evaluation. This is exactly why professionals from specific industries are often excluded from juries dealing with highly technical cases in their field. The jury's role is to provide ordinary moral intuition, not expert technical reasoning.
Okay, so we have this incredibly radical system where ordinary common sense intentionally trumps elite state-sponsored expertise. But how did this actually begin? Was there some grand democratic convention centuries ago where a group of visionaries sat down and designed this perfect defense against tyranny?
Not even remotely. In fact, it started as the exact opposite.
Okay, here's where it gets really interesting because tracing this history reveals a massive irony. This system, which is universally famous for restraining the power of the state, was actually invented by the state to solidify its own absolute control.
Yeah, it's one of the great accidents of legal history.
Yeah.
If we trace the roots back to England, shortly after the Norman conquest in the 11th century, William the Conqueror and subsequent kings were really trying to establish a unified judicial order across a heavily fractured land.
But the king is sitting in a castle in London, and, communication in the 11th century is incredibly slow. He can't possibly know what's going on in every small village in Yorkshire or Cornwall.
No, of course not. And he couldn't enforce his rule without that knowledge. The royal judges who traveled around the country holding court needed a mechanism to figure out what was actually happening on the ground, like who truly owned that piece of land, who stole the blacksmith's cow.
Right.
Moreover, the royal judges needed the local society to recognize and accept their rulings. Otherwise, they'd face constant rebellion.
So what do? They can't bring the whole village into the court, so they gather up a small group of local free men?
Exactly. They use these local men to provide collective statements under oath about the facts of a local dispute. But initially, this institution was absolutely not designed to protect the rights of defendants. It was purely an investigative, administrative tool of royal power.
Wow.
Yeah, the jurors were basically functioning as informers of fact for the king's judges.
They were local snitches for the crown. Like, they were literally just there to tell the royal judge what happened so the judge could drop the hammer and collect fines for the king.
That is essentially how it started, yes. But then, as the 12th and 13th centuries rolled around, the royal itinerant courts matured, and the common law began to take shape. And a profound, gradual shift occurred on the ground.
Tell me how that friction actually led to a shift. Because going from royal snitch to independent defender of liberty is a massive leap. How did that mechanism accidentally evolve?
Well, it came down to leverage. The royal judges quickly realized that they couldn't just drop into a village, issue a ruling entirely based on their own royal authority, and then leave. The locals simply wouldn't respect the verdict. For a verdict to stick, the community had to feel ownership over it. So the local informers of fact realized that the king's judges desperately needed their cooperation to maintain order.
So the locals started realizing, wait a minute, you can't actually do this without us.
Exactly. They transitioned from merely answering specific questions about who did what, to establishing their own authority, to determine the ultimate question of guilt or non-guilt.
And the judges just let them.
The judges allowed this because an independent verdict from 12 local peers carried undeniable legitimacy. It quelled local unrest far better than a royal decree ever could.
They basically built a wall against the very royal authority that created them, brick by brick, out of the king's own need for administrative efficiency. I mean, the king creates this tool to exert control, and the tool turns around and says, actually, we're the ones who decide who is guilty now.
It is a remarkable transformation. By stepping into that role, they became a core institution that restrained royal authority and safeguarded individual rights.
And that historical independence, that evolution from mere informers to ultimate deciders, really set the stage for a concept that completely blew my mind in this text. It's what many consider the jury system's most revolutionary characteristic, something that operates completely outside the boundaries of the written law.
Ah, you were referring to jury nullification.
Yes. When I dug into this part of the philosophy, my jaw genuinely dropped. Because from the time we are kids, we are taught that the law is the law. It's a rigid boundary. If you break it, you pay the price.
Right, that's the standard expectation.
But jury nullification is the power of a jury to acquit a defendant based entirely on considerations of justice, fairness, or conscience. Like, even if the prosecution proves beyond a shadow of a doubt that the written law was broken.
It is the ultimate expression of the jury's power. Within the common law system, if a jury looks at a case and feels that a law is fundamentally unjust, or that applying the law in this specific instance would be deeply unfair to the defendant, they can simply say, not guilty. And the mechanism stops right there.
To make this concrete, imagine a hypothetical scenario where an authoritarian government passes a perfectly legal-sounding statute that says it is a felony to publish any criticism of the mayor. Okay? And a journalist writes an article exposing the mayor's corruption, and they are put on trial.
A classic authoritarian move.
Right. The prosecutor shows the jury the article. The law was clearly broken, but the jury, made up of ordinary bakers and blacksmiths and teachers, looks at the law, looks at the journalists, and says, no, we aren't convicting him.
And what makes that so powerful is that the state can't do a single thing about it.
Wait, really? The prosecutor can't appeal the factual verdict. They can't go to the judge and say, look, they clearly ignored the evidence.
No, they cannot. The sheer magnitude of this power is breathtaking. Such a verdict requires zero legal justification from the jury. They do not have to explain their reasoning to anyone. Furthermore, it is not subject to judicial review. By design, a jury's determination of innocence is absolutely final.
That is staggering.
Now, parties may appeal issues of sentencing or procedure if there was a mistrial, but the state cannot appeal an acquittal. To allow the state to overturn a jury's acquittal would be to say the state is superior to the collective conscience of the people, which destroys the entire foundation of the system we just talked about. Absent incredibly rare exceptions regarding procedural fraud, the case cannot be retried. The acquittal stands.
A dozen ordinary people can just look at the full weight of the state's legal code, look at the prosecutor, and say, no, we don't think that's right.
And if we connect this to the bigger picture, this is exactly why authoritarian regimes harbor deep existential suspicions toward the jury system.
Because you can't control it. I mean, you can bribe a judge, you can rewrite a legal code, but you can't reliably control 12 randomly selected citizens behind closed doors.
Exactly. Authoritarian systems rely on absolute, predictable control over the legal apparatus. They need the law to function as a reliable conveyor belt for their political will. But jury nullification represents a black box of moral judgment within the judicial process that lies completely beyond the full control of the state.
It's described as a direct institutional means of resisting unjust laws or governmental abuse of power. It really is the last defense of the common people.
And history bears this out constantly. In cases of political persecution, religious suppression, or restrictions on free speech, juries have repeatedly served as a crucial force against state oppression. They have thwarted governmental attempts to cloak tyranny under the guise of legality.
Because even if the dictator writes a perfectly legal law, the jury serves as the ultimate safety valve.
It is. Which is why the analysis we are exploring argues that the jury system isn't just a judicial mechanism for solving crimes. It is fundamentally a profound form of political education.
I really like that framing. It takes this chore, this summons we groan about at the mailbox, and elevates it into something incredibly noble.
It forces free individuals, through concrete real-world cases, to actually bear the heavy responsibility of judging justice and injustice. It isn't an abstract theory you debate at a dinner party anymore. You are sitting in a room, the door is locked, and the fate, liberty, and reputation of another human being is literally in your hands.
You have to listen to differing views from your fellow jurors, you have to separate facts from your own emotional biases, and you have to assume deep moral responsibility for what happens next. That experience is one of the essential social foundations that helped representative democratic government mature.
It transforms political participation from an abstract ideal into a serious, inescapable burden. And this is exactly why the founders of the United States place such immense value on it. There is a very powerful quote from Thomas Jefferson regarding this that perfectly encapsulates the stakes.
Yes, Jefferson famously said, "I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its constitution."
The only anchor. It is a profound statement. In his view, constitutional texts, no matter how beautifully written, no matter how brilliantly argued without the physical, institutional support of everyday juries, would ultimately just become empty words on parchment. It is through these countless concrete verdicts that juries actually breathe life into constitutional principles.
They are the ones actually applying the brakes on the street level. So to wrap up everything we've explored from this deep dive into the philosophy of the common law, we can distill this entire system down into three grand civilizational convictions.
First, that justice is not the monopoly of experts. It belongs to the community.
Second, that law is not merely a tool of rulers to control and manage the population.
And third, that state power must always ultimately submit to the scrutiny of ordinary human conscience.
Ordinary people are institutionally recognized as the true judges of justice, not just passive subjects who are expected to obey the law. It really does change how you look at that envelope in the mail, doesn't it? It isn't an inconvenience. It is an invitation to exercise one of the deepest, most hard-won achievements of our civilization.
It's an institutional arrangement that allows that innate natural law to come alive in the real world. Written laws can be repealed, judicial techniques will evolve with technology, but the sense of justice within the human heart remains the final arbiter of a free society.
It's really powerful. But it also leaves me with a thought that I want to pass on to you listening right now. The entire common law jury system we've discussed today is built on this beautiful historical assumption, the idea that humanity shares a universal common sense and a collective moral conscience, that deep down, a baker, a tech CEO, and a teacher all share the same baseline compass of right and wrong.
Right, that's the core premise.
But as you look around at our increasingly fractured, polarized modern world where people can't even agree on basic facts, let alone morality, what happens to the justice system if we reach a point where 12 randomly selected citizens no longer share that baseline understanding? If the universal conscience splinters, what happens to the verdict? The next time you groan at that jury summons in your mailbox, ask yourself, does the anchor hold?